Hello there, my name is Hannah Maswani and I'm the Director of Mission and Equity Consulting with YWCA McLean County. And for this week, in light of last week's leak of the opinion draft by Justice Alito, I'd like to chat about the ways that we discuss and frame and devalue abortion in US society. So last week saw the leak of a draft ruling that seeks to challenge not only the legitimacy, but the legality of Roe v. Wade. And this opinion brief, seeks to revive laws that ban all abortions within 15 weeks or after 15 weeks of gestation, that is, after 15 weeks of conception. This Supreme Court decision, noting that the Supreme Court is majority men and that this opinion draft was written by a man who will never have children, the decision expected by the end of June. To give you the facts for a wee bit of a review, a mini history lesson for y'all, it was in 1973 that Roe v. Wade established the constitutional right, the protected right to abortion before fetal viability, which occurs at 23 or 24 weeks of pregnancy. So as long as you're before the 23rd or 24th week of pregnancy, abortion is legal. That is the case up until very many recent state legislations that have sought to interrupt that. I want to take a wee second to put a pin in the time at which Roe v. Wade occurred in 1973. This was sort of at the precipice. I won't say the tail end because civil rights is always an issue. The movement is always going, but this was at the sort of as racial justice was becoming more of a conversation. Black and brown folks were being given more rights, and the discussion on abortion became another highly politically charged, value-laden, deeply politicized issue for what some folks would call conservative values to sort of cling on to, right? And so we see in the early 70s this sort of bubbling up of pro-life or anti-abortion discussion. And Roe v. Wade was in part in response to that, to protect a woman's right to bodily autonomy. To give y'all a wee bit of an overview of what abortion looks like in the United States at this moment in time, 1 in 4 women in the US will have an abortion in their lifetimes. This current document by Justice Alito makes no exemptions for rape, or incest. And I want to amplify that at this point of recording in 2022, 1 in 3 women will also be the victims of sexual assault or sexual violence. And it's important to note that these two statistics do not exist in isolation. These aren't two separate worlds. And it is fair to say that there's likely some overlap between these statistics, right? And so not all pregnancies occur for the same reasons. Not all abortions are sought for the same reasons, right? If we're talking about the ways in which it impacts the person being asked to carry the child. For those of you who've watched my presentations before, you know that I will always bring in a wee bit of interest convergence in terms of the economic ramifications of the topic du jour, which today is abortion. A typical abortion costs about $550, depending on what clinic you go to. There are so few clinics, and currently the law in a lot of states, particularly in the South, is such that you have to go in for sort of a pre-consultation, making sure you are of sound mind, making sound decisions, Some states will have you listen to the ultrasound. If you've driven past a Planned Parenthood, you know that the person seeking an abortion or folks just seeking pap smears have to run through a line of pro-life protesters. So all of that aside, going back to the economics, it costs about $550 minimum just for the procedure. That does not account for any wages lost for time off being for the pre-visit, the procedure itself, healing from the procedure, or any childcare required for any part of that equation. 70% of patients who do seek abortions are hourly employees, which means they do not qualify for paid time off. So if you're not working, you're not earning. And a lot of times, especially in this market where everyone is understaffed, it is extremely difficult to get time off work. I know for folks watching, you're like, yep, that's the case. And 60% of people who receive abortions already have at least one child. So when we're talking about the financial ramifications of folks seeking an abortion, it's not something that is done lightly, although common rhetoric and popular misconception would have us believe that. It is quite literally an investment in a person, particularly a woman's bodily investment, and it is an investment that costs not just time, but buku money. And when we talk about bodily autonomy, I want us to think about it as not just the woman's decision to choose not to carry the fetus, or because of whatever reason is salient to her body, her choice, but the autonomy that being able to secure an abortion provides you for the rest of your life. So women who are refused abortions will experience a 78% rise in debt and an 81% increase in the likelihood of bankruptcy or eviction. And that typically is from being forced to carry a child to term, to give birth to a child that for whatever reason they did not feel they were able to, or whether that's financially, emotionally, depending on the conditions under which the child was conceived, any innumerable reasons that it's honestly not my business to question because I am not the one pregnant, right? And for those who were granted abortion access compared to those who are not, they saw a 40% increase in employment, that coming from the freedom of not being forced to carry a child to term that they were unable to or unwilling to carry. Since the Texas ban, which I talked about in an earlier video for our Think About It Thursday series, which you can check out on our YouTube channel, one solo Planned Parenthood in Denver has documented a 520% increase in patients from Texas. 520% increase. So I amplify that statistic to show the gravity of it all. Pardon me there. So been a day. But also to show that simply because abortions are made illegal or made increasingly cumbersome doesn't mean that people do not still need them and that they're not still going to find ways to get them. This is something that you can read about in any number of books about women's history and about abortion justice. In Oklahoma, which only has 6 abortion clinics, they've seen waiting times increase from 2 to 3 days to multiple weeks. So what we're seeing is an already congested system stripped bare of so many of the other opportunities that other healthcare facilities might have, being sort of driven to bare bones here, because where there was access in states that do still legally offer access, because of the influx of folks from states that are prohibiting access, and we'll talk about those in a wee bit, we're seeing wait times increase exponentially. And so if we think about the decision to move from 24 weeks to 15 weeks, again, a lot of women will not know that they're pregnant until a couple of months in, or maybe a month and a half in. If we factor in that you need to have the sort of pre-visit sort of consult period before the actual abortion process, what we're seeing with things like a 520% increase is the likelihood that even if a woman might qualify under what Alito's new proposal is, the sheer lack of resources means that they might time out of being able to achieve an abortion, which is at the moment their constitutional right. So this is not new. As I mentioned, since 1973, there have been over 1,300 abortion restrictions enacted. Again, 1,300. In 1992, so you'll notice if you read the brief, which I have read all 75 pages of, it is against Roe v. Wade and then also Casey v. Planned Parenthood. 1992 was the case of Casey v. Planned Parenthood, which sought to affirm the basic ruling of Roe v. Wade. And so Justice Alito and company are seeking to undermine both and strike down abortion as being unconstitutional. What's fascinating about this, in addition to the language, which we will dive into together, is that a poll just this January showed that only 30% of Americans say they'd like to see the Supreme Court get rid of Roe v. Wade. So again, only 30%, 1 in 3, just under 1 in 3 surveyed Americans don't want to see abortion legal. However, my very talkative dog, and the 69% of other respondents want to see Roe v. Wade upheld, want to maintain the constitutional right to abortion, and then also want to see their state move toward more permissive abortion laws. They're pro-choice. The majority of Americans are pro-choice, regardless of the fact that since April of this year, a further 536 restrictions on abortion have been introduced in 42 states. So what we're seeing, if we look at the numbers, is a huge dichotomy, this sort of chasm between decision makers being very, very much anti-abortion, and then the sort of mass populace of folks whom those decision makers purport to represent are more pro-choice. These are some of the states here you'll see in purple that are known as the trigger states, where if Justice Alito and friends have his way, these are the states that will most directly be impacted and might see abortion made completely unconstitutionally and completely illegal. Justice Alito, in his draft, begins with the statement that Roe was egregiously wrong from the start. And so when we're talking about the separation of church versus state, when we're talking about the sort of neutrality of law, I want us to do a little bit of a document analysis together to show how much the language of this opinion draft, how much the language of this brief is deeply value laden, and how in many ways it contradicts itself. So page 40 of the draft, Alito writes that Roe was on a collision course with the Constitution from the day it was decided. And Casey, the 1992 decision, Casey v. Planned Parenthood, perpetuated its errors. And the errors do not concern some arcane corner of the law of little importance to the American people. And we'll get into some of the semantics of this here. But the very phrase that he kicks off so strongly that it's on a collision course with the Constitution and makes very clear his own personal beliefs in ways that one would hope to not see from a legal framework that, again, purports to separate church and state and purports to speak for those whom elected officials are sought to represent, right? The IWP, or the Institute for Women's Policy Research, stated that the national cost to implement state-level abortion restrictions is over $100 billion. So while Alito will say that Roe was egregiously wrong from the start, it is, if I may say, egregiously expensive to continue state-level restrictions. And as mentioned in the earlier graphic, there are 13 states that have already passed trigger laws that are sort of waiting to jump into effect if in June, Alito wins with this draft. So as I mentioned, nerd alert, love language, love seeing how it can tell us a lot about the motivations and the values of the different drafts that we're reading, in this case, Alito's anti-abortion draft. So he kicks off by saying that the history of abortion ranged from constitutionally irrelevant to plainly incorrect. And I invite viewers to consider who was irrelevant at the time that the Constitution was drafted, knowing that at the time of the Constitution, a document written exclusively by white men, women were not mentioned once. People of color were not mentioned once. Babies were not mentioned once. There were no medical professionals who were there at the drafting of it. He offers citations of plainly incorrect that he then fails to deliver on. And because abortion was not mentioned, it's an odd choice to say it was incorrect if it was not mentioned. So there's sort of many nuanced small contradictions throughout this document, but then also really rather large ones. He continues on the second page of his brief that the court did not explain the basis for this line of protecting potential life, and even abortion supporters have found it hard to defend Roe's reasoning. Throughout this document, which I invite you to read, or any of the sort of synopses, including this one of it, there's a lot of language that is not evidence-based and has a lot of the tenets of a moral panic. And in order to have a moral panic, or what sort of qualifies as a moral panic, is anything that we're likely to believe or that public sort of mass hysteria can be generated around, where you don't really need evidence. And in this document, Alito doesn't provide evidence. Who are these even abortion supporters that he references? He does not offer any sort of documentation of individuals or cases against abortion, excuse me. In the years prior to Roe, pardon my typo, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restrictive regime on the entire nation. I will not purport to be a lawyer. However, if you look at the history of the different legislations that did try to liberalize the laws, there is some salt there, right? So we can see that there is a sort of back and forth history of folks being for and against this, much in the same way that we see a back and forth history in terms of how people have been for Black lives, or have been pro-immigrant, or have been pro women's rights in general, right? But what's interesting about, a lot of things are interesting about this document, but what's particularly striking is the way in which he frames Roe v. Wade as being more conservative and against the liberalization of different state laws. So please consider this. The draft seeks to limit the availability of abortions to 15 weeks, which is, again, quite literally more conservative time frame than the current metric of 24 weeks. Yet throughout his language, in an almost poetic irony, Alito deliberately seeks to frame Roe v. Wade as being the more conservative option that stood against liberalization. Let that sit with you for a wee minute, because he sort of flip-flops what liberal and restrictive mean in a way that is political at best. Alito discusses that for the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. Not only are we discussing that the first 133 years of this country did not mention women, and women were not allowed to vote, it is also in direct contradiction to the current views of US citizens, as I mentioned earlier from the SRSS poll from CNN, where 69% of people would like to see Roe v. Wade upheld. So again, this sort of mistruth being represented by Alito here, stating that we used to be able to support the people that we represent, but Roe v. Wade won't let us. Whereas here, the people, 69%, support Roe v. Wade, but he's going against it using the very same sort of mechanism that he's trying to stop. Under this scheme of Roe v. Wade, each trimester pregnancy was regulated differently, that is each state restriction. And I say here simply that it still is, because we see with the Texas ban that they not only tried to limit the term of viability of pregnancy from the date of conception, but the document itself, that the Texas heartbeat ban, I believe it was referred to as, considers pregnancy not from the moment of conception, but from the last day of the woman's most recent period, before this woman may or may not have even engaged in any sex in any way in which to have conceived. So we're still seeing pregnancy regulated super differently in ways that advantage those who are more pro-life, but he sort of skips over that. Again, there's literally no mention of women or their rights until the challenge that there was no clear guidance between a due and undue burden that a woman might endure. So this document does not mention women. It discusses an interest in potential life, and then fails to discuss what a due and undue burden is. And as a woman, as somebody who believes in empowering women, as part of an organization that believes in empowering women, to have a piece of legislation drafted exclusively by men is one thing that is already individually hard to swallow. But to have a piece of legislation written exclusively by men that fails to mention women is kind of next level, because here we're seeing women's opinions as secondary to men's opinions about what women's bodies should be and what a burden should or should not be to them. Again, remembering that I stated that women who are denied abortion are 81% more likely to experience bankruptcy and eviction. To me, that feels like an undue burden. That is not addressed in this document either. Here we see some more examples of Alito's language, saying that some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy. And this buys into the myth that there's any number of late stage abortions. Oftentimes when we look to pro-life advocacy, and again, not all pro-life advocacy by any means, right? By any means. However, we'll see a lot of sensationalized media, kind of that moral panic that I mentioned, that discusses abortions at 36 weeks or what have you, which is quite literally birth. So we see this sort of exaggeration of a moral panic that sort of does away with the very real facts of how many restrictions there are. Again, there's been 438 new restrictions this year alone. I want us to consider how the following statement is framed. A key argument is made that the state of Mississippi's movement to prohibit abortion after the 15th week, i.e. before viability, necessitates overturning Roe v. Wade because there can be no half measures, as Mississippi would be in direct violation of Roe v. Wade. So it's, as somebody who does legitimately read legalese for fun. I don't have a social life. We're seeing so many contradictions. So effectively, what Alito is saying is that the state of Mississippi choosing to increase the restrictions on abortion would be against Roe v. Wade. So let's get rid of Roe v. Wade. That is kind of the heartbeat of that, because there can be no half measures, which if we go to our previous slide, he says that previously each state was permitted to address this issue in accordance with the views of its citizens. Here he frames that as a positive. Literally 2 pages later, he says that we can have no half measures. So he's contradicting himself in any number of ways. And that's why I chose to describe this as linguistic quicksand. He holds that Roe and Casey, or Roe v. Wade and Casey v. Planned Parenthood, must be overruled because, again, the Constitution makes no reference to abortion. It's not implicitly protected by any constitutional right. And again, who was represented in the Constitution? We have had innumerable, multiple, I should say, amendments to the Constitution, such that give women the right to vote, own property, allow Black folks the right to vote. But it seems that the very tenets of allowing amendments does not concern him or those who drafted this bill. So he goes on throughout this very long document that the inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment from the earliest. I want us to think about what else is not deeply rooted in the country's history and traditions. We are on stolen Indigenous land. We are all currently benefiting from the unpaid slave labor of Black folks. We currently are benefiting off of a prison industrial complex. We are currently living in a nation with a lot of proud history, but a lot of really dark history. When we think about the nation's history and traditions, tradition, for those of you who are in DEI work alongside me, know that tradition has been used to let a lot of egregious things fly by. We've always done it that way. Women never had the right to vote, things like that, right? And so we're seeing a lot of that same critical thought terminating language apply here, to the point where Alito is framing abortion as un-American. And that's where we get into sort of dangerous thematic use, dangerous rhetoric that is even more politically divisive than just pro-life and pro-choice. Here he discusses ordered liberty as setting limits and defining boundaries between competing interests. Again, noting that in this document and in the Constitution, women were not mentioned, children were not mentioned. He talks about how there's a balance between the interests of what they determined as potential life, and then the people of various states, and then how people of the various states may evaluate those interests differently. Again, this directly contradicts the purpose of the document, which was to not have half measures, whilst also saying that previously states could determine what they wanted. So he continues to contradict himself and continues to refer to potential life instead of the very real lives of women and trans folks who are carrying babies. Again, our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. This phrase in particular is one of the more seemingly sort of neutral, Gertie, please. However, it belies the fact that this has already been regulated. It has already been decided not once with Roe v. Wade in the 70s, but then again upheld with Casey v. Planned Parenthood in 1992. So we are seeing a sort of deliberate erasure of all of the advocacy that went into Roe v. Wade and Casey v. Planned Parenthood. We've long recognized, however, that stare decisis is not an exonerable command, and it is at its weakest when we interpret the Constitution. So that stare decisis, I'm probably pronouncing it wrong, I do apologize, is sort of like the way things have always been. It's not an exonerable command, but then again, it directly contradicts his earlier statement that our fine nation's history and tradition, right? He states that it's more important that it has sometimes been said that we settle something, then settle it right. Again, ignoring the fact that this issue has been settled in both the 70s and the 90s. He continues on to talk about that the Constitution is notoriously hard to amend, yet seeks a further amendment to undo the amendment that allowed for Roe v. Wade to exist. I invite you all to hit pause and to take a little moment to read this. He goes on to say that when one of our constitutional decisions goes astray, as have at least 24 of them in the past, the country is usually stuck with a bad decision unless we correct our own mistake. Again, ignoring the fact that this mistake, this oversight rather, of women and women's bodily autonomy and abortion justice was decided again in the 70s and 90s. I sound like a broken record during this video because there's so much to think about, because the themes of this document are ever so clear. He does uphold that neither decision, i.e. Roe v. Wade or Casey v. Planned Parenthood, has ended debate over the issue, but nor will this. There is a sort of, I'm struggling to find an appropriate word for it, but this sort of sense of omniscience that this document provides that sounds very Handmaid's Tale, shall we say, that is like, once we do this, there's no going back, which directly goes against the notion of being able to amend the Constitution, which is one that he himself has challenged before. So he sort of presents this document, he and those who drafted it with him, as like, this will end the debate. But as mentioned, 69% of folks who are surveyed in the US just this year alone don't want to diminish Roe v. Wade. He discusses the court's inability to end debate and how it shouldn't be surprising and how they cannot bring about a permanent resolution simply by dictating a settlement and telling people to move on. However, that's exactly what this brief is trying to do. And again, he said, whatever influence the court may have on public attitudes must stem from the strength of our opinion, not an attempt to exercise raw judicial power. And for me, this line as an individual strikes hardest because that is exactly what this document is doing. It is saying that this is not what it's about to do. This document states that Roe v. Wade and Casey v. Planned Parenthood, they were all trying to do this. They were all trying to exercise raw judicial power, but we're not, because we're going to end a debate that has never happened before. We might have influence on public attitudes. We're seeking to ignore them by pushing forward this document, and that it's not raw judicial power, though that is effectively what it is seeking to be. And we will find out in June, in next month, whether it's successful or not. And so, as I mentioned earlier, the words woman, women, sex, girl, gender do not appear in the Constitution at all until the 19th Amendment. So while they hold that Roe and Casey must be overruled, they say the Constitution makes no reference to abortion, which would be rather difficult to make reference to considering women weren't acknowledged. And he brings up that it is not implicitly protected and that we cannot look towards the 14th Amendment for such protection. The 14th Amendment being that of privacy, which I will get into. Again, I want to amplify this quote that Roe v. Wade was on a collision course because women were not mentioned in the Constitution. And so I firmly believe to love our country is to want to create a safe community free from fear, allowing folks access to bodily autonomy, to agency, to well-being. And he frames that as directly in contrast to the Constitution. And he says that the 14th Amendment is not one by which we can uphold Roe v. Wade or Casey v. Planned Parenthood. So the 14th Amendment is a guarantee of the 5th and 14th Amendment, rather, to protect certain substantive rights that are not listed or enumerated in the Constitution. So pretty much the 14th Amendment comes on in and is like, hey, the Constitution didn't talk about everybody. We might have missed some people, a lot of people. And so we want to also offer support to those innumerable or enumerated sort of shadowy rights that we have not discussed. We want to offer procedural due process, or procedures that the government must follow before it deprives an individual of life, liberty, or property. Life, liberty, and property. Think about those in the context of abortion, of a woman or a trans man seeking abortion, right? Or a non-binary person, excuse me, as well. So procedural due process for that person seeking an abortion, that is literally their life. It is their liberty. It is, if we consider our bodies our own property, their own property. However, the 14th Amendment coupled with the 5th and 9th Amendment says that the Constitution does not cover everything. So while Alito is trying to say that the Constitution never mentioned abortion, he's kind of flipping past 3 separate amendments that acknowledge some of the shortcomings or some of the oversights, I should say, of the Constitution. This sort of substantive due process did have a renaissance. We saw it in 1965 when, for the right of privacy or the freedom of contract is allowed, right? So for people in the US, for citizens to have the right to privacy, we are allowed to use contraception if we want to, right? It's the sort of penumbras or the shadowy edges of the constitutional rights. So recap, Alito saying Constitution never mentioned abortion, it should be illegal, but what he's not doing is addressing at least 3 really, really important amendments to the Constitution. And it's important that we see the discussion on the sort of war against abortion in a number of different ways, predominantly to uplift bodily autonomy of those seeking abortion, predominantly to allow freedom and justice and liberty for all, right, as our Constitution would have us hope for. But when we start ignoring the 14th, 5th, and 9th Amendments, we're also ignoring other rights that have been attacked variously in legislation by those who lean sort of more traditional / conservative. Again, not all folks, but some folks, right? So if we eliminate the right to privacy from the penumbra, right, or for those who are not directly mentioned in the Constitution, for example, LGBTQ folks, we were not mentioned in the Constitution, but we are sort of caught in the sort of umbrella of the penumbra or the shadows of individuals who were not seen, but who still deserve rights. If we interfere with that and undo abortion justice, we're a whisper away from banning same-sex marriage. We're a whisper away from criminalizing queerness. And I invite you to hit pause, take a wee sec to look through some of Medley's work. They write for them. The doing away of the right to privacy could quite literally bring back anti-sodomy laws. It could bring back, again, the illegitimacy of same-sex marriage. It could bring back any weaponizations against women and minoritized and historically persecuted peoples. So if you're watching this and maybe abortion isn't something that is salient to you or relevant to you, or you think everybody should have their own choice, I agree with you there. We have to think about how misrepresentation of the Constitution and its amendments sort of offer this domino effect of stripping away various rights of people who were not those who originally wrote the Constitution. Because when we talk about the Constitution, yes, we can uplift our forefathers, but we cannot ignore the amendments that have brought us closer to a fair and just society, right? Or our aspirations of a fair and just society. So there are heavy implications here, absolutely, for women and folks who will be denied abortion if this goes through, but also for folks of different faith groups, for folks of different sexual orientations, for folks who practice love differently, right? If we choose to undo amendments, we choose to undo basic human rights. And so again, as I mentioned, his double standards here, the ways in which he sort of flips conservative to be more liberal and liberal to be sort of more protective. It's a fascinating document. I really encourage y'all to read it. Please don't just trust my take on it, right? And we see that even though Roe has been on the books for over 50 years, he states that stare decisis, or the way that things have always been how they are, is not enough, while also the real keystone of his argument being the Constitution stare decisis, or the way it has always been, is what we should uphold, right? And so he's claiming Roe's abuse of judicial authority while also seeking to do the exact same thing he claims Roe has done. He said that instead of bringing on a national settlement of the abortion issue, Roe v. Wade and the follow-on decisions of Casey v. Planned Parenthood just inflamed debate and deepened division. And that is exactly what we're seeing after the leak of this document, right? we're seeing a lack of privacy being afforded to women and folks who may need an abortion. And instead, we're seeing an increased rhetoric of, well, who in Congress did this? We need more privacy than the people we are supposed to represent, right? And to him, the inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history, as I mentioned, but whose nation's history? And if we truly look at our nation's history and traditions, we have to include those amendments that do offer protections, because we can't grocery shop human rights and we can't grocery shop how we look at our history. And so he says, we do not pretend to know how the political system will respond to today's decision. Although, again, the statistics I mentioned earlier do give us a fair inkling that 2/3 of folks are in favor of upholding Roe v. Wade. And then he says that he ends this opinion where we began. He says that Roe and Casey aggregated the authority and that he seeks to overrule it. And he ends it with the 4 very haunting words of "it is so ordered." And as dystopian as that sounds, and as much as we want to put that on a shelf and not think about it, there are such deeply, deeply real implications for this. Because again, when we start undoing amendments, when we see folks go after single issues that for some may be easy to buy into, or some may not really be bothered about, again, we're allowing for amendments to sort of be erased from history. And when we do that, we're stripping ourselves of our rights. And for those of you who are seeking to help or to be more informed, I highly encourage you to check out Politico, where you can read the entire document. I believe it is about 75 pages. I've given you some of the highlights here, but please take the time to educate yourself, inform yourself on what's going on. And there's a live Google Doc. If you just quite literally Google abortion funds in every state, you can see these 13 states that are the trigger law states. So these states that are poised to completely ban abortion should Alito's draft be welcomed and enacted into law. Oftentimes we see when there's significant cases like this, folks want to be able to give money, but we're not sure where it'll help most. I highly encourage you to check out this document here. Again, just Google Doc abortion funds in every state, or if you check out politico.com, you will see the full draft from Alito, as well as any number of ways that you can help. And then for folks who are interested in learning more about the ways that this could be one of the many first dominoes that seek to deprive women and minoritized folks of their rights, I very much encourage you to check out reproductiverights.org/maps/what-if-Roe-fell, because while this issue is predominantly about abortion justice, about people's rights to choose what happens with their bodies, what happens in their lives, it is broader than that as well. And for folks who identify as pro-life, and for folks who believe in the sanctity of life, even within the womb, I encourage y'all to, instead of perhaps donating to these funds, donate to ways that we can support children once they are born, because there is such a deficit of childcare. There is such a deficit of social work. We see that, again, women who are denied access to abortion are 81% more likely to be at risk of eviction and bankruptcy, which means that the children that they were forced to birth are also victims of bankruptcy and eviction. And so regardless of where you stand on the matter of being pro-life or pro-choice or anti-abortion or what have you, find ways that you can contribute to this dialogue in meaningful ways. And then to whatever degree you have the time, talent, or treasure to support folks on whatever side of this, whether you believe in women's rights to choose or in children's rights in utero, please consider those rights after birth as well. And so I have been Hannah Maswani, your Director of Mission and Equity Consulting with YWCA McLean County. I welcome any questions on this draft and on any of the upcoming discussions that we know will be happening as a result of this. So please stay tuned to your local news sources. Again, I encourage you to always look for firsthand sources. So check out the document from Alito himself. Perhaps you'll have a wildly different interpretation of it than I did, and I welcome that discussion with you in any way that you like. So thank you very much for tuning in.